Disclaimer: the content provided on this channel is for general informational and educational purposes only. It is not legal advice. I am not a licensed attorney. Viewing this content, commenting, or engaging in any communication with the creator of this channel does not create an attorney-client relationship, nor is any communication considered privileged or confidential. The law is complex and varies significantly by jurisdiction. The information presented may not be applicable in your specific state or country. For advice on your individual legal situation or issue, you must consult with a licensed attorney in your jurisdiction. Do not act or refrain from acting based on the content of this channel.
The envelope looks official. Government business. Your hands are a little damp as you tear it open. And there it is. The seal of the county court. A jury summons. Your heart does a little tap dance against your ribs. A dozen questions explode in your mind. Do I have to go? What if I say the wrong thing? What do I wear? My boss is going to kill me. For millions of Americans every year, this single piece of paper is their first, and often only interaction with the United States justice system. And it is terrifying. Why? Because most of what we think we know about the inside of a courtroom is a complete lie. We've all seen it. The slick, fast-talking lawyer from Suits who wins the case with a single brilliant gotcha moment. The dramatic, last-minute witness in Law and Order who bursts through the doors to confess everything. The judge who slams their gavel down and shouts, "Order in the court," every 5 minutes. It's fantastic television. But it's also pure fantasy. Real courtrooms aren't about dramatic confessions and surprise evidence. They are slow, methodical, and governed by a dense web of rules and procedures that can feel like a foreign language to an outsider. The truth is, the gap between a TV courtroom and a real American courtroom is as wide as the Grand Canyon. On TV, the lawyer objects, shouts, badgering the witness, and the judge makes a snap decision. In reality, that same objection might trigger a 10-minute-long debate between the lawyers and the judge at the bench, speaking in hushed tones you can't even hear, referencing obscure case law from 1987. On TV, a trial lasts for a 45-minute episode. In reality, just selecting a jury can take days. This gap between fiction and reality is a huge problem, because when you get that jury summons or you're called as a witness, or you have to go to traffic court, you're not walking onto a TV set. You're walking into a real-world system with real-world consequences, and you're armed with nothing but Hollywood fiction. That feeling of being unprepared, of not knowing the rules of the game, that's what we're going to fix. Right here, right now. This is not a law school lecture. This is your field guide. Your beginner's manual to what actually happens inside a U.S. courtroom. Over the course of this presentation, we are going to pull back the curtain and demystify every single aspect of this intimidating world. We're going to turn your confusion into confidence. By the time you're done watching, you will understand the secret language of the court. You'll know what objection sustained, leading the witness, and motion to strike actually mean and why they matter. You will know every key player on the field and exactly what they do, from the judge in the black robe and the court reporter typing 1,000 words a minute, to the bailiff who is so much more than just a security guard, and the court clerk who might just be the most powerful person in the room. We will walk you step by step through the entire anatomy of a trial. We'll start before you even enter the courtroom, with the surprisingly crucial process of jury selection, or voir dire. We'll break down opening statements, why the first 5 minutes can win or lose a case. We'll dive deep into the heart of the trial, the presentation of evidence. You'll learn the difference between direct examination and cross-examination, and why one is about building a story, while the other is about tearing it down. We'll cover closing arguments, the final, passionate plea to the jury. And finally, we'll explore the jury's deliberation, that secret process behind closed doors, and the moment of truth, the verdict. This isn't just for people on jury duty. This is for anyone who's ever been a witness, fought a traffic ticket, or simply been curious about one of the most fundamental, yet misunderstood, pillars of American society. The goal here is simple: to replace fear with knowledge, to give you the confidence that comes from understanding the process, the people, and the purpose behind everything that happens inside those four walls. Because let's be honest, the courtroom is designed to be intimidating. The architecture itself is meant to convey power and authority. The judge's bench is elevated, forcing everyone else to literally look up to them. The flags, the official seals, the formal, almost ritualistic language, it's all calculated to create a sense of awe, and for the average person, a sense of being small and out of your element. It's a stage, and on that stage, a very serious drama unfolds. But it's a drama with rules you can learn. It's a play where you can understand the script. Think of it this way. Imagine being dropped into a foreign country where you don't speak the language, know the customs, or understand the currency. That's what walking into a courtroom feels like for most people. You don't know who to talk to, where to stand, or what to say. You're afraid of breaking a rule you didn't even know existed. This video is your translator. It's your cultural guide. It's the map that shows you how to navigate this foreign land with confidence. Understanding this process is a form of power. It's the power to serve on a jury and make a truly informed decision that will change someone's life. It's the power to be a witness and give your testimony clearly and effectively, without being rattled by a lawyer's tactics. It's the power of a citizen who understands how their own justice system works, its strengths, its flaws, and its profound impact on our daily lives. We're going to strip away the jargon and the mystery. We're going to give you the unwritten rules, the things that veteran lawyers and judges know that the public doesn't. For example, why do lawyers almost never ask a question they don't already know the answer to on cross-examination? What's the real reason you're not supposed to talk about the case, even with your spouse? Why is the court reporter one of the most critical people for ensuring a fair trial? We will answer all of these questions and so many more. So, forget everything you learned from Hollywood. Let's get real. Our journey begins not in the courtroom itself, but at the front door of the courthouse. Because the moment you step through those heavy doors and face the metal detectors, the process has already begun. The environment, the security, the sheer scale of the building, it's all part of the system designed to set a specific tone. This is the first test, the first step in transitioning from the outside world into the unique and highly controlled ecosystem of the law. Let's walk through those doors together. The first thing you hit is a security checkpoint. Feels just like an airport, but the stakes feel infinitely higher. There's the gray plastic bins for your keys, your wallet, your belt, the conveyor belt for your bag, the walk-through metal detector. But the faces of the officers here are different. They aren't TSA agents looking for oversized shampoo bottles. These are sheriff's deputies or court marshals. They are armed, and they are not here to make your journey comfortable. They are the gatekeepers. This process is designed to do more than just find weapons. It's a psychological reset. It's the first and most physical reminder that you are leaving the world of personal freedom and entering a world of absolute rules. You take off your belt not just because it might have metal, but as a small act of submission. You empty your pockets to show you have nothing to hide. Your phone, your connection to the outside world, must be silenced or, in many courts, surrendered entirely. This is a deliberate and effective way of stripping you down, of making you a neutral element before you enter the system. You are now on their turf, playing by their rules. Fail this first simple test of compliance by arguing, by making a joke, by forgetting the knife on your keychain, and you might not even make it past the lobby. Once you're through, the world opens up into the main atrium. And this is where the scale of the operation becomes clear. The sounds are different in here. Footsteps echo on polished marble or linoleum floors. Voices are hushed, creating a low, constant murmur of anxiety and quiet negotiation. The air itself seems heavier. High above, the ceilings might be ornate, vaulted, or just impersonally high, but the effect is the same. To make you, the individual, feel small and insignificant in the face of the institution of justice. Your eyes will inevitably be drawn to a screen or a large board. It might be a digital monitor or a classic felt board with white plastic letters. This is the docket, and it is the single most important piece of information in the entire building. The docket is the daily schedule for the court. It's a dense list of names, times, and numbers that can look like an alien language at first. But it's your map. It'll list the case number, the names of the parties involved like Smith versus Jones, or the people of the state of California versus Miller, the name of the judge presiding, and most importantly, the courtroom number. Without finding your name on that list, you are utterly lost. And as you stand there deciphering this code, you start to see the human drama unfolding all around you. This lobby is a waiting room for life-altering events. Look around. You'll begin to recognize the key players in this ecosystem. First, you'll spot the lawyers. They're the easiest to identify. They move with a purpose the others lack. They're in suits, maybe not expensive ones, but it's their uniform. They carry briefcases, leather-bound folders, or rolling bags stuffed with documents. They often travel in pairs or small groups, speaking in a rapid-fire shorthand. You'll see them greeting the security officers by name. They know this world. This is their office. Watch them. You'll see some huddled with their clients, giving last-minute instructions in hushed, urgent tones. You'll see others, the opposing lawyers, sharing a coffee and a laugh. It can be jarring to see two people who will be trying to professionally destroy each other in 10 minutes talking like old friends. But for them, it's just another day at the office. The conflict is professional, not personal. Most of the time. Then you'll see the litigants. These are the plaintiffs and the defendants, the people whose lives are at the center of the day's proceedings. They look just like you. They're wearing their good clothes. A shirt and tie that's a little too tight. A dress saved for church or weddings. But their faces give them away. You'll see every shade of human emotion. Fear is the most common. The wide-eyed, deer-in-the-headlights look of someone who has no idea what's about to happen to them. You'll see anger, a rigid jaw and clenched fists. You'll see exhaustion, the deep soul-crushing weariness of someone who has been fighting for months or years. They are the reason everyone else is here. Yet they often seem the most out of place, like unwilling guests of honor at a terrifying party. Scattered among them are the witnesses. They're the ones who often look the most uncomfortable. They've been subpoenaed, which is a formal-sounding word that means they were legally ordered to be here. They aren't the accused or the accuser. They're just people who saw something, heard something, or know something. They're taking a day off work, often unpaid, to sit on a hard bench and wait for their name to be called, so they can go into a room of strangers and talk about what might have been the worst day of someone else's life. They'll be sitting alone, nervously checking their phone or staring at the floor, just wishing they were anywhere else. And finally, you'll see the jury pool. If there's a big trial starting, you'll see a large group of ordinary citizens, a cross-section of your community herded together. They're holding a summons, looking vaguely confused and annoyed. They are the bedrock of the American justice system, the jury of your peers. They are the audience the lawyers will perform for, the human lie detectors who will ultimately decide what is true and what is not. Right now, in this lobby they are just a crowd. But in a few hours, 12 of them will be given an immense and terrible power. The power to decide someone's fate. As you make your way from the lobby down the long, quiet hallways, you'll notice something else. A huge amount of the court's business never happens in the courtroom. The hallways are where the real work gets done. You'll see two lawyers duck into an alcove for a hallway conference. This is where deals are made. The prosecutor might offer a last-minute plea bargain. The civil attorney might propose a settlement figure. The system is overwhelmed and it encourages these resolutions. A deal made in the hallway is one less trial the judge has to oversee. It's practical, it's efficient, and it's a part of the process most people never see. This is also why you never ever talk about your case in the hallway. You have no idea who is listening. That person walking by could be a juror, a witness for the other side, or a reporter. The walls literally have ears. Finally, you find it. The right number on a heavy wooden door. Courtroom C, the Honorable Judge Eleanor Vance presiding. There might be a small, glass-wired window on the door, too high to easily see through. Next to the door, a printed sheet of paper is often taped to the wall, listing the cases for the day, a smaller version of the main docket. You check it one last time. Yes, this is the place. Now you pause. This is the final threshold. Before you reach for that handle, you do a mental check. Your phone is off. Not on vibrate. Off. A phone ringing in a courtroom is like a fire alarm in a library. It's a cardinal sin, and a judge can and will fine you or kick you out for it. You adjust your clothing. No hats. No sunglasses. You are preparing to enter a formal space. You are not a spectator at a movie. You are a participant in a solemn, state-sanctioned ritual. You take a breath, trying to calm the adrenaline coursing through you. You can hear the low, muffled sound of a voice from inside. The proceedings have already begun. You place your hand on the cool, heavy brass handle. The door feels impossibly heavy. Pushing it open, you feel a shift in the air pressure. You are stepping out of the chaos of the hallway and into the crushing, structured silence of the courtroom itself. The first thing that hits you isn't a sight, but a smell. It's the scent of old wood, floor wax, and something else, paper. Millions of pages of it. The accumulated dust of countless stories, arguments, and verdicts seems to hang in the air like a fine mist. And then there's the silence. It's not an empty silence. It's a heavy, weighted silence, thick with anticipation. Every cough, every shuffle of a shoe, every rustle of a jacket feels like a sacrilege, a stone thrown into a perfectly still pond. Your eyes adjust to the low, solemn light, often a mix of imposing chandeliers and fluorescent fixtures that hum with a barely audible electric prayer. The room is a cathedral of consequences, and everything in it is designed to make you feel small. The ceilings are high, impossibly high, drawing your gaze upward as if to some unseen authority. The walls are paneled in dark, Imposing wood, oak, mahogany, or walnut. Polished to a dull sheen over decades. It absorbs sound, it absorbs light, and it seems to absorb all hope of a casual outcome. This is not a place for negotiation. It's a place for judgment. Your attention is immediately pulled to the front, the focal point, the altar. It's the judge's bench. But bench is a ridiculously humble word for this structure. It's a fortress of wood and leather, elevated on a platform called a dais. This isn't just furniture. It's a deliberate, architectural statement of power. The judge doesn't sit with you. They preside over you. Looking up at that empty, high-backed leather chair, you instinctively understand the hierarchy. From that vantage point, the judge sees everything and everyone. A panoramic view of the human drama about to unfold. Behind the bench, sealed and imposing, are the flags of the United States and the state, and often, the grand seal of the court, a constant, silent reminder of the authority this room represents. To one side of the judge's bench, looking lonely and exposed, is the witness stand. It's a simple chair and a small lectern, often enclosed in a low wooden box. This is the hot seat, the spotlight. It's intentionally placed so that the witness is facing not just the judge, but the entire room and most importantly, the jury. There is nowhere to hide. Every twitch, every hesitation, every bead of sweat is on full display. It's a stage for one, where truth is meant to be extracted under the immense pressure of a dozen pairs of eyes. And those eyes belong to the jury. Look to the side of the room and you'll see the jury box. It's a tiered section with 12 chairs, plus a few extras for alternates. It's the only part of the room designed for a group of equals. They are the audience that matters. The 12 deciders. They are citizens, plucked from their daily lives to become the conscience of the community. They are meant to be a cross-section of society, and their collective judgment is the bedrock of the entire system. Their box is positioned to give them a clear, unobstructed view of the witness, the judge, and the lawyers. They are the human element in this rigid, formal machine. Down on the main floor, directly in front of the judge's bench, are two large tables. This is the battlefield. The counsel tables. One for the prosecution or the plaintiff, the party bringing the case, and one for the defense. This is where the lawyers, the gladiators of this arena, will operate. They are stacked with binders, legal pads, laptops, and exhibits. You can almost feel the nervous energy radiating from these tables, even when they're empty. This is where strategies are whispered, objections are planned, and the entire narrative of the case is launched. Now let's talk about the people. Because a courtroom is just a room until the players arrive. You might think the most important person is the judge, or maybe the lawyers. But the person who actually makes the entire proceeding function, the person with more practical power than almost anyone else, is someone you might not even notice at first. Look near the judge's bench, at a desk that sits slightly lower. That's the court clerk. The clerk is the administrative heart of the court. They are the keeper of the official record, the handler of all evidence, the person who swears in witnesses, and the one who reads the verdict aloud when it's all over. They manage the flow of paperwork that can drown even the most experienced lawyer. The judge might be the captain of the ship, but the clerk is the navigator, the quartermaster, and the chief engineer all rolled into one. They know the rules, they know the procedures, and they know where everything is. An unhappy clerk can make a lawyer's life a nightmare. They are the gatekeepers of the process. Then there's the physical presence of the court's authority. The bailiff. You'll see them, usually in a uniform, standing watchfully, often near the judge or the jury box. Their official job is to maintain order and security. They are the ones who call the court to order with that iconic phrase, "All rise." They escort the jury in and out. They handle prisoners if it's a criminal case. And they are the silent, ever-present reminder that the court's rulings are not suggestions. They are commands backed by the force of the state. The bailiff is the shepherd of the courtroom, ensuring the decorum and solemnity of the proceedings are never broken. They are the wall between order and chaos. And there's one more person in this room, often sitting silently in a corner or near the witness stand, whose role is absolutely critical. They are the court reporter. You'll see them sitting before a strange-looking machine, their fingers flying across it in a blur of silent motion. That machine is a stenotype, and their job is to create a perfect word-for-word transcript of everything said in the courtroom. Every question, every answer, every objection, every ruling from the judge. They are the scribes of justice, the official memory. What they type becomes the record, the sacred text that can be reviewed by higher courts on appeal. In a world of arguments and conflicting stories, the court reporter's transcript is the closest thing to objective truth. They are the silent guardians of history, ensuring that what happens in this room is not lost to the winds of memory. The clerk, the bailiff, the court reporter. They are the essential machinery, the gears that allow the wheels of justice to turn. But the engine, the driving force of the conflict, is still missing. Your eyes are drawn back to those two empty counsel tables. One side represents accusation, the other defense. One seeks to prove a story, the other to dismantle it. These tables are waiting for the adversaries, the storytellers, the legal warriors who will soon stand and fill this crushing silence with words that have the power to build a case or tear a life apart. And at one of these tables sits the architect of the accusation. In a criminal case, this is the prosecutor. They don't work for a person, they work for the state, for the government. Their client is an idea, the people, the Commonwealth, society itself. When you see a case titled The People versus John Doe, this is who they mean. They are the voice of the collective, arguing that a societal rule has been broken and a debt must be paid. In a civil case, this person is the plaintiff's attorney, representing the individual who claims they've been wronged, who is seeking not prison time, but compensation, or a court order to make something stop or start. But regardless of the case type, this first lawyer has one monumental task that defines their entire existence in this room: the burden of proof. This is one of the most critical and most misunderstood concepts in the entire American legal system. The burden of proof means it is their job, and their job alone, to build a case from the ground up. The person on the other side, the defendant, doesn't have to prove a thing. They can sit there in complete silence for the entire trial and, in theory, still win. It's the accuser who must build the mountain. The accused just has to see if it crumbles. Imagine the prosecution's case is a tower of blocks. They must find each block, a piece of evidence, a witness statement, a forensic report, and carefully, meticulously, stack them one on top of the other. Each block has to be solid, legally obtained, and placed just right. If they build the tower high enough, strong enough, it becomes a conviction. And how high does that tower have to be? Well, that depends on what's at stake. In a civil case, where the penalty is usually money, the standard is called a preponderance of the evidence. It's a fancy way of saying more likely than not. Think of the scales of justice. If the plaintiff's attorney can make their side dip just a fraction of an inch lower than the other, 50.1%, they win. It just has to be slightly more convincing than the other side's story. But in a criminal case where a person's liberty is on the line, the standard is astronomically higher. It's the most famous phrase in all of law: beyond a reasonable doubt. This doesn't mean beyond any doubt. It doesn't mean you have to be 100% certain with no fantastical what-if scenarios left. But it means the tower of blocks the prosecutor has built must be so tall, so solid and unshakable, that any reasonable person looking at it would say, yes, that person did it. There can be no other logical explanation for the facts presented. It means the evidence must foreclose any reasonable theory of innocence. The prosecutor's job is to eliminate every single one of those reasonable doubts, one by one, until only the story of guilt remains. This is a massive, crushing weight. Now look at the other table. Here sits the deconstructor, the demolition expert, the defense attorney. This is perhaps the most maligned and misunderstood role in the entire courtroom. You've heard the question 1,000 times. How can you defend someone you know is guilty? It's a question that misses the entire point of the American justice system. The defense attorney's primary job is not to prove their client is innocent. Let me say that again because it's crucial. Their job is not to prove innocence. Their job is to ensure the government proves guilt, legally, constitutionally, and beyond a reasonable doubt. They are the shield. They are the ultimate quality control on the government's power. They are the living embodiment of the principle that it is better for 10 guilty men to go free than for one innocent man to be convicted. Their client, the defendant, is wrapped in a powerful, almost sacred protection: the presumption of innocence. This isn't just a nice idea. It's a legal force field. At the start of the trial, the defendant is, in the eyes of the law, a completely innocent person. And it is the defense attorney's job to maintain that force field at all costs. So while the prosecutor is building that tower of blocks, the defense attorney is walking around it, inspecting it from every angle. They're tapping on the blocks, looking for cracks. Is that piece of evidence shaky? Was it obtained with a faulty warrant? Is that witness's memory unreliable? Does their story change under pressure? They are there to test the integrity of the prosecution's case. They don't need to build their own tower. A competing story of innocence. Sometimes they do, presenting an alibi or an alternative suspect. But often, their most effective strategy is simply to show the jury that the prosecution's tower is unstable. All they need to do is pull out one or two key blocks and watch the whole thing collapse into a pile of reasonable doubt. This dynamic creates what we call the adversarial system. It's not a cooperative search for truth. It's a battle, a structured, rule-bound conflict of narratives. The theory is that by having two skilled, motivated adversaries giving it their absolute all, one to prove a story, the other to dismantle it, the truth will be forged in the fire of that contest. The weaknesses in one argument will be exposed by the strengths of the other. Lies will be uncovered through cross-examination. The truth, hopefully, is what survives the ordeal. And make no mistake, it is an ordeal. For these lawyers, this isn't a television show. It's their life's work, played out in real time with catastrophic stakes. They've spent months, maybe years, living with this case. They've sacrificed nights and weekends, poring over thousands of pages of documents, interviewing witnesses, strategizing, and second-guessing every decision. They carry the weight of a victim's quest for justice, or a defendant's entire future, on their shoulders. When they stand up to speak, their heart is pounding, their adrenaline is surging, because they know that the words they choose in the next few hours can alter the course of human lives forever. They are storytellers, strategists, and warriors, armed not with weapons but with arguments. And every word they are about to say, every piece of evidence they are about to present, is aimed at one specific target. It's not the judge. It's not the opposing counsel. It's a small group of ordinary people, sitting quietly to one side of the room watching everything. They are the most important people here, the silent arbiters of fate who hold all the power, yet will barely speak a word until the very end. They are the jury, and persuading them is the only thing that matters. But how do you persuade a group of strangers you've never met? And more importantly, how are those strangers even chosen? It's not like the lawyers get to handpick their 12 favorite people from the phone book. The process is one of the most misunderstood, most strategic, and most intensely human parts of any trial. It's a high-stakes psychological drama that unfolds before the first piece of evidence is ever presented.
Etiquette voir dire.
That's voir dire. It's an old French term that literally means to speak the truth. And it all starts with a letter, an official-looking envelope that arrives in your mailbox, summoning you for jury duty. For most people, it's a mix of civic pride and a deep sense of dread. You have to rearrange your work, your family life, your entire schedule, all to go sit in a government building and wait. You arrive at the courthouse and are herded with hundreds of other people into a large, sterile room called the jury assembly room. It's the DMV of the justice system. You wait. You read a book. You scroll on your phone. And you wait some more. Then a clerk calls out a list of numbers or names, and if you're called, you're led into a courtroom. This is where the real process begins. You and about 50 or 60 other potential jurors, known as the venire panel, file into the courtroom and take seats in the public gallery. You see the judge, the lawyers, the defendant, and they are all looking at you, sizing you up. The judge begins by explaining the nature of the case in broad strokes, and then starts asking basic questions. Do you know anyone involved in this case? The defendant, the lawyers, any of the potential witnesses. Have any of you been a victim of a similar crime? Is there any reason, any at all, why you could not be a fair and impartial juror in this matter? People raise their hands. They explain their connections, their experiences, their biases. And this is where the first cuts are made. These are called challenges for cause. If a potential juror says something that clearly shows they can't be neutral, for example, "My son is a police officer, so I will always believe a cop's testimony over anyone else's," the judge will dismiss them. There's no limit to these challenges. If half the room is clearly biased, half the room goes home. But this is just the warm-up act. The main event is when the lawyers get their turn. They are not looking for the 12 most fair-minded people in the room. Let's be brutally honest about this. They are looking for the 12 people most likely to be sympathetic to their side of the story. They are trying to eliminate the people most likely to be sympathetic to the other side. It's a strategic game of elimination. Each side is sculpting the jury, trying to mold it into a group that will see the world and the evidence through their preferred lens. The prosecutor in a drunk driving case might ask the panel, "How many of you feel that it's okay to have 1 or 2 drinks and then drive home?" They're not looking for an honest debate. They're identifying people who are permissive about drinking and driving. The defense attorney will then stand up and ask, How many of you believe that just because a person is arrested by the police, they must be guilty of something? They're looking for people who are skeptical of authority. They'll ask about your job, your hobbies, what TV shows you watch, what newspapers you read. A prosecutor might love a juror who is an accountant, someone detail-oriented who follows rules. A defense attorney might prefer an artist or a social worker, someone who might be more attuned to emotional nuance and human fallibility. They are trying to read you. Your body language, the way you answer, the clothes you wear. It's part science, part psychology, and a healthy dose of pure guesswork and stereotyping. And this leads to the most powerful tool the lawyers have, the peremptory challenge. Unlike a challenge for cause, where you need a legitimate reason to dismiss someone, a peremptory challenge allows a lawyer to strike a potential juror for almost any reason at all. They don't have to explain it to the judge. They can just say, "Your Honor, the defense would like to thank and excuse juror number 7. And just like that, you're out. Maybe they didn't like the way you looked at their client. Maybe your bumper sticker was for a political candidate they despise. Maybe your profession as a high school science teacher makes them think you'll be too analytical and won't buy their emotional appeal." Each side gets a limited number of these strikes. The number varies by state and the type of case, but it could be anywhere from 3 to 10. And they use them like a surgeon uses a scalpel, carefully excising the jurors they fear the most. This is where the real strategy comes in. Do you use a precious strike on the guy who seems a little too pro-police? Or do you save it for the woman in the back who might be even worse? It's a high-stakes chess match. Now, there is one massive exception. The Supreme Court has ruled in a case called Batson v. Kentucky that you cannot use a peremptory challenge to strike a juror because of their race, ethnicity, or gender. If a prosecutor, for instance, uses all their strikes to get rid of every single African American juror on the panel, the defense attorney can raise a Batson challenge. The judge will then force the prosecutor to provide a race-neutral reason for each of those strikes. But this is a notoriously tricky area. A lawyer can often come up with a plausible-sounding reason: "I didn't like their body language," or "their occupation as a musician suggested a lifestyle incompatible with the seriousness of this case," that masks an underlying bias. It's an imperfect system trying to deal with the imperfect reality of human prejudice. Slowly, juror by juror, the panel is whittled down. Those who are struck for cause leave. Those who are struck by peremptory challenges leave. The remaining people move from the gallery into the jury box until 12 seats are filled. Then, a few alternates are chosen who will listen to the entire case and step in if one of the main jurors has to leave for an emergency. Once the jury is finalized, a profound shift happens in the courtroom. These 12 people are no longer just random citizens. They are now officers of the court. The court clerk asks them to raise their right hands, and they take an oath, swearing to well and truly try the matter, and a true verdict render according to the evidence and the law. In that moment, the weight of the entire system settles onto their shoulders. The judge then gives them a stern set of instructions. They are forbidden from discussing the case with anyone, not their spouse, not their friends, not even each other until the official deliberations begin. They are forbidden from doing any independent research. No Googling the defendant. No visiting the scene of the crime. No looking up legal terms. They must decide the case based only on what is presented inside that courtroom. In our modern age of instant information, this is an almost superhuman act of discipline. In extremely rare, high-profile cases, the jury might be sequestered. This is the stuff of movies. It means they are completely cut off from the outside world for the entire duration of the trial. They live in a hotel, their phone calls are monitored, their TV and internet access is restricted, and they are escorted by bailiffs everywhere they go. This is done to prevent them from being influenced by intense media coverage or public opinion, but it's an extreme measure that happens very, very rarely. For the vast majority of trials, the jurors go home every night. They go back to their jobs, their families, their lives, all while carrying the secret of the trial inside them. They sit in that jury box day after day listening. They are the ultimate passive audience. They can't interrupt. They can't ask questions during testimony. They just have to absorb a tidal wave of information. Forensic reports, eyewitness accounts, complex legal arguments, and try to keep it all straight. They are watching a story being told from two completely different points of view, and their job is to find the truth somewhere in between. The entire rhythm of the courtroom is now dictated by them. Lawyers know that after lunch, jurors can get sleepy, so they might save their most dramatic witness for that post-meal slump. They know that a juror who is frowning or crossing their arms might not be buying their argument. Every single word, every gesture, Every piece of evidence is now aimed at those 12 people in the box. They are the only audience that matters. And with the jury finally seated, sworn in, and ready to listen, the trial proper is ready to begin. The stage is set. The actors are in place. The curtain is about to rise on the main event. And it all starts with a story. 2 stories, actually. The prosecution gets to go first, standing up before the jury to deliver their opening statement, their version of what happened, their promise of what the evidence will show. This opening statement is not evidence. The judge will say this. The lawyers will say this. But make no mistake, it is one of the most powerful moments in the entire trial. It's the first impression. It's the lens through which the jury will view every piece of testimony and every single exhibit that follows. A great prosecutor won't just list facts. They'll paint a picture. They'll tell a human story. They'll stand in front of those 12 jurors and say something like, "The evidence will show that on the night of August 14th, the defendant, driven by greed, made a choice. And that choice shattered the life of an innocent family. Over the next few days, we are going to build a case for you piece by piece. We will present witnesses who saw him, forensic evidence that places him at the scene, and his own words that betray his guilt. When we are finished, we are confident that you will see the truth, and that you will hold him accountable." It's a promise, a roadmap to a guilty verdict. They are setting the theme, defining the stakes, and pointing the finger directly at the defendant. Then it's the defense's turn, and their strategy can be very different. Remember, the defense has no burden of proof. They don't have to prove their client is innocent. They only have to create a reasonable doubt about the prosecution's story. So their opening statement might be a counter-narrative. What the prosecutor just told you is one version of events, a theory, but the evidence will actually show a very different picture. It will show a shoddy investigation, a rush to judgment, and a focus on the wrong person. Or they might be more subtle, more focused on undermining the state's case before it even begins. They might say, "The prosecution has made a lot of promises to you. They've used strong words like proof and certainty. Your job as jurors is not to take their word for it. Your job is to listen critically, to look for the gaps, to pay attention not just to what they present but to what they don't present. And we believe that when you do, you will be left with one thing: reasonable doubt." The 2 stories have been told. The battle lines have been drawn. Now the prosecution has to back up its words. This begins the next and longest phase of the trial, the case in chief. The prosecution goes first because they have the burden of proof. They must present evidence to prove each element of the crime beyond a reasonable doubt. They do this primarily by calling witnesses to the stand. One by one, they will call people to testify. It could be the police officer who first arrived on the scene, the victim of the crime, an eyewitness who saw something crucial, or an expert witness like a DNA analyst. When a lawyer calls their own witness, the questioning is called direct examination. The goal of direct examination is to build a narrative. The lawyer wants the witness to tell their story to the jury in a clear, compelling way. And there's a huge rule here that TV shows often get wrong. On direct examination, you are generally not allowed to ask leading questions. A leading question is one that suggests the answer. For example, a prosecutor can't ask their witness, "You saw the defendant fleeing the scene in a red car, didn't you?" That's leading. It puts words in the witness's mouth. Instead, they have to use open-ended questions to let the witness tell the story themselves. Sounds like this: "Where were you on the night of August 14th? What did you observe at approximately 10 p.m.? Can you describe the car you saw? What happened next?" It's a carefully choreographed dance. The lawyer is guiding the witness, letting them lay down the bricks of the story one fact at a time, building a foundation for the jury. But testimony is just one kind of evidence. There's also physical evidence, or what lawyers call exhibits. This can be anything: the weapon, a signed contract, photographs of the crime scene, text messages, a map, security footage. But you can't just walk up to the jury and show it to them. There's a formal process. First, the lawyer asks the court clerk to mark the item for identification. "Your Honor, I'd like to mark this photograph as People's Exhibit 1 for identification." Then they have to lay the foundation. This means they have to call a witness who can authenticate the exhibit. They show the photo to the witness on the stand and ask, "I'm showing you what's been marked as People's Exhibit 1. Do you recognize what's in this photograph?" The witness says, "Yes, that's my house." The lawyer then asks, "Does this photograph fairly and accurately depict the condition of your house on the night of the incident?" The witness says, yes. Now that the foundation is laid, the lawyer can formally offer it into evidence. Your Honor, the prosecution offers Exhibit 1 into evidence. The judge will then ask the other side if they have any objection. If not, the judge will say, Exhibit 1 is admitted, and only then can it be shown to the jury and considered as proof. Now let's talk about the most dramatic word in any courtroom drama. Objection. Lawyers don't just shout this to be disruptive. They are enforcing the rules of evidence. The entire system is built on the idea that a jury should only hear reliable, relevant information. Objections are the tool to keep the bad stuff out. There are dozens of possible objections, but here are some of the most common. We already talked about leading on direct examination. Another huge one is hearsay. Hearsay is, in its simplest form, an out-of-court statement offered to prove the truth of the matter asserted. Confusing, right? Let's break it down. A witness can't get on the stand and say, "My neighbor Bob told me he saw the defendant do it." That's hearsay. Why? Because Bob isn't the one on the stand. He can't be sworn in, the jury can't see his demeanor, and most importantly, the defense lawyer can't cross-examine him. The information is considered fundamentally unreliable. The witness can testify about what they saw, what they heard, what they did. They can't testify about what Bob told them. Another common objection is relevance. The evidence has to actually relate to the case. A prosecutor can't start asking a witness in a bank robbery trial about their vacation to Florida last year, unless it somehow connects to the case. If it doesn't, the defense will stand up and say, "Objection, relevance." Then there's speculation. A lawyer can't ask a witness to guess what was going on in someone else's head. What do you think the driver was planning to do? Objection, speculation. The witness doesn't know. They can only testify to what they saw the driver do. When a lawyer objects, the other lawyer might respond, and the judge makes an instant ruling. If the judge says sustained, it means they agree with the objection. The lawyer has to rephrase the question or move on, and if the witness already answered, the judge will instruct the jury to disregard that statement. Of course, you can't unring a bell, but that's the procedure. If the judge says overruled, they disagree with the objection, and the witness can answer the question. This back and forth of questions, answers, and objections continues for every single witness the prosecution calls. But the testimony isn't over once the prosecutor says, "No further questions," because now the other side gets their turn. And this is where the real fireworks happen. This is cross-examination. If the goal of direct examination is to build a story, the goal of cross-examination is to take a wrecking ball to it. The defense attorney now gets to question the prosecution's witness. Their objective is to poke holes, to challenge credibility, to expose bias or a faulty memory. And the biggest rule change is this. On cross-examination, leading questions are not just allowed, they are the weapon of choice. The defense lawyer wants to control the witness, to pin them down, to get simple yes or no answers. They are not asking the witness to tell a story. They are telling a story to the witness and forcing them to agree with it piece by piece. It might go something like this, with the defense questioning an eyewitness. "The incident happened at night, correct?" "Yes." "And it was raining?" "Yes." "You weren't wearing your glasses at the time, were you?" "No." "You were standing over 100 feet away?" "I guess so, yes." "So you'd agree the visibility wasn't ideal?" See what's happening? The lawyer isn't calling the witness a liar. They are systematically dismantling the certainty of their testimony. They are planting seeds of doubt in the jury's mind about how well the witness could really see what they claim to have seen. This adversarial process, this duel between direct and cross-examination, is the engine of the American trial system. It's how the truth is supposed to emerge from the clash of two opposing stories, tested under oath, one witness at a time. The prosecution builds them up, and the defense tries to tear them down. And after the prosecution has called all of its witnesses and presented all of its evidence, they will stand before the judge and say the 5 words that signal the halfway point of the trial. The prosecution rests its case. The air in the courtroom shifts. It's a palpable change, like the pressure dropping before a storm. For days, maybe even weeks, the entire room has been focused on one narrative, one story told by the state. The jury has seen the prosecution's best photos, heard their best witnesses, and examined their best evidence. The prosecution has fired every bullet in its gun, and now they're empty. For the defendant, this moment is both terrifying and liberating. The onslaught is over. Now it's their turn to fight back. But before the defense can even think about calling their first witness, their lawyer will almost always do something that seems incredibly bold. They will stand up, face the judge, and essentially ask for the entire case to be thrown out right then and there. This is called a motion for a directed verdict, or a motion for judgment of acquittal. The defense lawyer is arguing that, even if the jury believes every single word the prosecution's witnesses said, and even if they accept every piece of the prosecution's evidence as 100% true, it's still not enough to convict. They're telling the judge, "Your Honor, based on the evidence presented, no reasonable jury could possibly find my client guilty beyond a reasonable doubt. They haven't met their burden. The case should end now." Think of it like a boxing match. The prosecution has had several rounds to try and land a knockout punch. The motion for a directed verdict is the defense telling the referee, "Look, they haven't even laid a glove on my guy. There's no point in continuing this fight. Just declare us the winner." Now, does this motion ever actually work? Rarely. It is almost always denied. The bar is incredibly high, and judges are very reluctant to take the decision away from the jury. So why do defense attorneys do it every single time? 2 reasons. First, on the off chance the prosecution's case really is that weak, it could work. But the main reason is strategic. It preserves the issue for an appeal. If the defendant is convicted, their lawyer can later argue to a higher court that the judge should have granted that motion and ended the trial. It's a crucial legal chess move, protecting their client's rights for the future. Once the judge inevitably denies the motion, the real show begins. The defense now has the chance to present what's called its case in chief. This is their story, and it begins with the single most important, most high-stakes decision in the entire trial. Does the defendant take the stand? The Fifth Amendment to the United States Constitution is legendary. It guarantees that no person shall be compelled in any criminal case to be a witness against himself. This is the right to remain silent. The defendant does not have to testify. Period. If they choose not to, the judge will specifically instruct the jury that they cannot, under any circumstances, hold that silence against them. They can't even discuss it in their deliberations. In the eyes of the law, that silence is a complete non-factor. But in the minds of the jury, it can be a different story. So the defense attorney and the defendant have an agonizing choice to make. If the defendant testifies, they get to look the jury in the eye and tell their side of the story. They get to be a human being, not just a name on a docket. They can say, "I didn't do it." They can explain where they were. They can clarify confusing evidence. A credible, likable defendant on the stand can be the most powerful weapon the defense has. It can single-handedly create reasonable doubt and win the case. But the risk is catastrophic. Because the moment the defendant takes that stand and swears that oath, they have subjected themselves to cross-examination by the prosecutor. And a prosecutor's job during cross-examination is not to find the truth. Their job is to destroy the witness's credibility. They will use every legal tool in their arsenal to trip the defendant up, to make them look angry, flustered, evasive, or worse, like a liar. They'll ask confusing, compound questions. They'll twist the defendant's words. They will be relentless. A defendant who seems nervous or who has a poor memory, or who gets angry on the stand can look incredibly guilty, even if they're completely innocent. And there's an even bigger danger. Testifying can open the door to devastating evidence that the jury otherwise would never have heard. Let's say a defendant has a prior conviction for theft from 10 years ago. Normally, the rules of evidence would prevent the prosecutor from ever mentioning that, because it's not relevant to the current charge and would be unfairly prejudicial. But if the defendant gets on the stand and says something like, "I'm an honest person, I would never steal anything," they have just opened the door. The prosecutor can now potentially introduce that prior conviction to rebut the defendant's claim of being an honest person. In an instant, the jury goes from seeing the defendant as a person accused of one crime to seeing them as a convicted criminal. It can be an absolute death blow to their case. This decision to testify or not to testify is a monumental gamble. It's why you often see defense lawyers looking so stressed. They are weighing the potential for a game-winning home run against the risk of a catastrophic, game-losing error. Whether the defendant testifies or not, the defense will then build the rest of their case by calling their own witnesses. This is where they construct their alternative narrative. They might call an alibi witness. This is the classic. "He couldn't have committed the crime, because he was with me at the movies." A strong, confident alibi witness can be a silver bullet. But under cross-examination, that alibi can crumble. The prosecutor will press for tiny details. What movie did you see? Who was the lead actor? What did you eat? What was your server's name? What time did you leave? If the alibi witness's memory is shaky on any of these minor points, the prosecutor will suggest to the jury that they're either mistaken, or worse, lying to protect their friend. The defense may also present a battle of the experts. If the prosecution brought in a DNA expert who said the defendant's DNA was at the scene, the defense might bring in their own DNA expert to challenge the findings. Their expert might testify that the sample was too small, that the testing procedure was flawed, or that the lab has a history of making mistakes. The goal isn't necessarily to prove the prosecution's expert is a liar. It's to introduce enough technical doubt that the jury starts to think, well, I don't know who to believe, so I guess I'm not sure. And not sure is reasonable doubt. Finally, the defense might call character witnesses. These are people, a boss, a pastor, a neighbor, who take the stand simply to say that the defendant is a person of good character, known for being peaceful and honest. The idea is to convince the jury that the crime is completely out of character for the person they know. But just like with the defendant testifying, this can be risky. If the defense presents evidence of the defendant's good character, it can open the door for the prosecution to rebut it with evidence of their bad character, which is normally forbidden. Alongside witnesses, the defense will present its own physical evidence. Security camera footage from a different location showing the defendant was there. Phone records, receipts, emails. Anything that supports their version of events and pokes holes in the prosecution's timeline. Remember, the defense does not have to prove the defendant is innocent. They don't have to prove who did commit the crime. They don't have to solve the case. Their one and only job is to create reasonable doubt about the prosecution's story. They are professional doubt creators. They are attacking the foundation of the state's case, brick by brick, until the whole structure looks like it might collapse. And after the defense has called its last witness and entered its last piece of evidence, the defense attorney will rise, just as the prosecutor did, and say the words that signal the end of their story. The defense rests. The main evidentiary portion of the trial is now over. Both sides have presented their cases. But the fight isn't quite finished, because the prosecution gets one last chance to strike back. This is called the rebuttal. It's not a do-over. The prosecution can't just call a witness they forgot to call the first time or rehash their entire case. The rebuttal is a laser-focused counterattack. Its sole purpose is to challenge new evidence or a new theory that the defense introduced. Think of it like a debate. The prosecution makes its opening argument. Then the defense gets to respond. But what if the defense, in their response, brings up a completely new point the prosecution couldn't have possibly anticipated? It would be unfair to just let that new point stand unchallenged. The rebuttal is the chance to say, hold on a second, let's talk about that. For example, let's go back to our robbery case. The prosecution's case-in-chief established the defendant was at the scene. The defense then puts the defendant's best friend on the stand who testifies, he couldn't have done it. He was with me across town watching a movie at that exact time. This is a classic alibi defense. It's new information. The prosecution, in their case-in-chief, had no reason to disprove an alibi that hadn't been raised yet. So, during their rebuttal, the prosecution could call a new witness. Maybe it's a theater employee who can testify that the movie the friend mentioned wasn't actually playing that night. Or perhaps they have cell phone tower data that they didn't need before, but which now directly contradicts the alibi by placing the friend's phone nowhere near the movie theater. This evidence isn't just reproving their original case, it's directly demolishing the defense's alibi. That is the essence of a rebuttal. It's a reactive, defensive move that can be devastatingly effective. And in the spirit of fairness, if the prosecution's rebuttal brings up something new, the defense might get a chance to respond to that. This is called a surrebuttal. It's even more rare and more narrowly focused. It's the law's way of ensuring no one gets the final word without the other side having a chance to reply to any new facts raised. Once this potential back and forth is complete, and both the rebuttal and any surrebuttal are finished, a quiet but momentous event occurs. The judge will look at the jury and say, the evidence is now closed. That's it. No more witnesses, no more exhibits, no more testimony. Everything the jury is allowed to consider as fact has now been presented. The universe of information they will use to decide someone's fate is now sealed. But before they can be sent back to the jury room to deliberate, they need a rule book. They need a guide. How are they, a group of 12 ordinary citizens, supposed to navigate the complex maze of the law? They aren't lawyers. They don't know the specific legal definitions of assault, or negligence, or intent. They don't inherently understand the most important principle in the entire American justice system, the burden of proof. This is where one of the most critical, and yet least dramatic phases of the trial takes place: the jury instructions. Often this happens while the jury is on a break out of the courtroom. The judge and the lawyers for both sides huddle together in what's called a charging conference. To an outsider, it would look incredibly boring. They're just reading through pages of dense legalistic text. But in reality, this is a ferocious, high-stakes battle. This is where the rules of the game are decided, and a single word can change everything. Each side submits their own proposed set of instructions to the judge. The prosecution wants instructions that frame the law in a way that is most favorable to their theory of the case. The defense wants the exact opposite. They will argue line by line over the precise wording. Should the instruction on self-defense include the phrase duty to retreat? Should the definition of possession include the concept of constructive possession? These might sound like minor semantic squabbles, but they are anything but. These phrases and definitions have been the subject of legal battles for centuries, and they can be the very hook on which an acquittal or a conviction hangs. The judge listens to both sides, consults massive books of pattern or model jury instructions, and makes the final call. The judge is the ultimate arbiter of the law. He or she will finalize the set of instructions that will be read to the jury. This is one of the most common grounds for an appeal. If a judge gives the jury an incorrect or misleading instruction on the law, a conviction can be overturned by a higher court. The lawyers know this, which is why they fight so hard, making sure their objections are on the record to preserve their right to appeal later. So what's actually in these all-important instructions? First, they get a set of general rules. The judge will tell them things like, you must not be influenced by sympathy, prejudice, or public opinion, and the arguments of the lawyers are not evidence. The judge will instruct them on how to weigh the credibility of witnesses, telling them to consider factors like the witness's demeanor, their motive for testifying, and whether their memory seems reliable. Then comes the most important part, the law itself. The judge will read the exact statute the defendant is accused of violating, and then the judge will break it down into what are called the elements of the crime. For the jury to find the defendant guilty, the prosecution must have proven every single element beyond a reasonable doubt. If even one element is not proven, they must acquit. For example, for a charge of first-degree murder, the judge might explain the elements are: 1. The defendant caused the death of another person. 2. The defendant acted with malice aforethought. And 3. The killing was done with premeditation and deliberation. The judge will then go on to legally define what malice aforethought, premeditation, and deliberation actually mean. The jury can't just use their own common-sense definitions. They must use the precise legal definitions provided by the judge. And finally, the judge will give the most crucial instruction of all, the one that underpins the entire system, the instruction on the burden of proof. The judge will look directly at the jury and explain, in slow, deliberate terms, what proof beyond a reasonable doubt means. They will explain that the defendant is presumed innocent, that the defendant has an absolute right to remain silent, and that the jury must not hold that silence against them in any way. They will explain that the burden of proof rests entirely with the prosecution. The defense bears no burden. They don't have to prove anything. The judge will explain that beyond a reasonable doubt is the highest standard of proof in the law. It doesn't mean beyond all possible doubt or a shadow of a doubt. A reasonable doubt is not a flimsy, speculative, or imaginary doubt. It is a doubt based on reason and common sense, arising from the state of the evidence. It's a doubt that would cause a reasonable person to hesitate to act in a matter of the highest importance in their own personal life. This single instruction is the shield that protects the innocent from wrongful conviction. It is the massive, heavy weight the government must lift to take away a person's liberty. Once this intense, off-stage battle over the instructions is complete, the jury is brought back into the courtroom. The air changes. The evidentiary phase is over. The legal rulebook has been written. The judge now turns to the jury, holding the finalized pages, ready to read them the law that will govern their decision. And once those words are spoken, once the jury is armed with their legal map, the stage is set for the grand finale. The last chance for the lawyers to speak directly to the jury, to take all the disparate pieces of evidence, the testimony, the documents, the photographs, and weave them all together into one final, powerful, and persuasive story. The closing arguments are about to begin. The prosecutor rises first. In a criminal case, the party with the burden of proof, The one who has to prove their case gets to speak first and last. It's a strategic advantage. They walk towards the jury box not with a script but with a story. This is their final performance. They're not presenting new evidence. They're not allowed to. Instead, they are the master weaver, pulling threads from every piece of testimony, every document, every photograph, and tying them together into a single coherent tapestry of guilt. They'll look each juror in the eye, reminding them of the promises made in the opening statement. "We told you the evidence would show," they'll say. And it did. They'll walk the jury back through the trial, moment by moment, connecting the dots. They'll point to the defendant and argue that all roads of evidence lead directly to that table. Their job is to make the jury's decision feel not just logical, but inevitable. They are building a fortress of facts, trying to leave no room for doubt to enter. Then the defense attorney gets their turn. Their job is the exact opposite. They are not the weaver. They are the deconstructor. They don't have to prove their client is innocent. They only have to show that the prosecution has failed to prove their case beyond a reasonable doubt. They are the voice of skepticism, the champion of doubt. They will walk to that same spot and begin to pull at the threads the prosecutor just wove. They'll highlight inconsistencies in testimony. Witness A said the car was blue, but witness B said it was black. Is that a minor detail, or a crack in the foundation of their story? They'll challenge the evidence. The forensics expert admitted on the stand that the test wasn't 100% conclusive. They will offer alternative theories not to prove them, but simply to show that other possibilities exist. Their closing argument is a cascade of what-ifs and could it be that. Their goal is to plant a seed of doubt, a reasonable doubt, in the mind of just one juror. Because in most criminal cases, that's all it takes. After the defense rests, the prosecutor gets one last chance. A brief rebuttal to address the points the defense just made. They will try to repair any holes poked in their narrative, to dismiss the defense's arguments as distractions, as smoke and mirrors designed to confuse the truth. And then they sit down. The talking is over. The impassioned pleas, the strategic arguments, the oratory. It all comes to an end, and the entire atmosphere of the courtroom shifts. The emotional, persuasive energy evaporates, replaced by a quiet, academic solemnity. The judge, who has been the silent referee for most of the trial, now takes center stage. This next phase is arguably the most critical and least understood part of a trial. The jury instructions. The judge becomes a law professor. They begin to read, often from a prepared script, a long and detailed set of rules that the jury must follow. This isn't a suggestion, it's a command. The judge explains the law, stripping it of all the emotion the lawyers just pumped into the room. They define the specific crime or civil claim. They break it down into its core components called elements. For a theft charge, for example, the judge will explain that the prosecution had to prove 1, that the defendant took property that belonged to someone else, 2, that they did it without permission, and 3, that they intended to permanently deprive the owner of it. If the prosecution failed to prove any one of those elements, the jury must find the defendant not guilty. And this is where the judge explains the single most important concept in the entire American legal system: the burden of proof. In a criminal trial, the judge will look at the jury and explain the meaning of beyond a reasonable doubt. This phrase is famous, but what does it actually mean? The judge will clarify that it does not mean beyond all possible doubt, or a shadow of a doubt. No one can be that certain about anything in life. Instead, a reasonable doubt is the kind of doubt that would make a person hesitate before acting in a matter of great importance in their own life. It's a real, substantial uncertainty, not just a flimsy, imaginary one. It's the highest standard of proof we have, a deliberate safeguard to protect the innocent from wrongful conviction. In a civil case, the standard is much lower. The judge will explain the preponderance of the evidence. This sounds complicated, but it's actually simple. It just means more likely than not. Imagine the scales of justice. If the plaintiff's evidence makes the scale tip ever so slightly in their favor, even 50.1%, they win. It's a dramatic difference from the near certainty required in a criminal case. These instructions are the legal map for the jury. They can't just use their gut feeling. They must take the facts as they have found them and apply this specific legal framework, as given to them by the judge, to reach their decision. Once the instructions are read, a bailiff stands. The judge looks to the jury and says something like, "You may now retire to the jury room to begin your deliberations." A door opens and 12 ordinary people file out of the jury box, leaving the packed courtroom in a state of suspended animation. They are led into a small plain room. There's a table, 12 chairs, and the evidence. The door closes and they are completely cut off from the outside world. No phones, no internet, no news. For the first time, they can speak to each other about the case. Their first task is to elect a foreperson. This isn't the jury's boss. It's their facilitator. The foreperson's job is to make sure everyone gets a chance to speak, to organize the discussion, and to handle the voting and communication with the court. From there, the process is up to them. Some juries start with an immediate vote to see where everyone stands. Others will spend hours or even days, methodically going through every single piece of evidence, rereading testimony, and debating every point. They can hold the alleged weapon in their hands, they can look at the crime scene photos up close, they can read the text messages for themselves. This is where the case is truly decided. It's a microcosm of democracy. 12 strangers with different backgrounds and beliefs, tasked with reaching a unanimous verdict. The arguments can be heated, the debates intense. People's deeply held beliefs about justice, fairness, and human nature come to the surface. If they get stuck or have a question, they can't just guess. The foreperson writes a note to the judge. Can we have the definition of intent reread to us? Or can we see Exhibit 14 again? The bailiff delivers the note and everyone is brought back into the courtroom, lawyers, defendant, everyone, to hear the judge answer the question on the record. Then they go back to the deliberation room, back to the debate, and while they argue and reason and vote behind that closed door, everyone else waits. The lawyers sit in the hallway drinking stale coffee, replaying the trial in their heads. The families of the victim and the defendant sit on hard wooden benches, staring at the courtroom doors, their lives hanging in the balance. Time stretches and distorts. An hour feels like a day. Every time a door opens, every footstep in the hall sends a jolt through the waiting crowd. This is the agonizing limbo between the trial and the truth. The jury is now in control. 12 citizens hold a life, a future, a company's fate in their hands, and no one knows what they're thinking, what they're saying, or when they will finally emerge with the one word that everyone is waiting to hear. The verdict. The heavy oak door clicks shut, and the sound echoes with a finality that sends a shiver through the room. For the first time, the 12 jurors are truly alone. The bailiff, the judge, the lawyers, the defendant, they're all gone. There is only a long table, 12 chairs, stacks of evidence, and the immense crushing weight of the law. This is the jury room. It's a place of forced intimacy and profound isolation, where strangers must come together to decide a person's fate. The first order of business is deceptively simple. They must elect a foreperson. This isn't about choosing the most popular or the most powerful person. The foreperson is a facilitator, a guide. Their job is to make sure every voice is heard, to organize the review of evidence, and to be the sole line of communication with the court. It's a role of immense responsibility, and the choice itself is the jury's first collective decision, a test of their ability to work together. Once the foreperson is chosen, the real work begins. Where do you even start? Imagine being handed dozens, sometimes hundreds of exhibits. Police reports, financial statements, photographs, text message logs, maybe even the weapon itself, now sealed in a clear plastic bag. You have to look at everything again. You have to touch the evidence, pass it around the table, see it with your own eyes, free from the lawyer's spin. The jury instructions from the judge, a dense packet of legal definitions and rules, are read and reread, dissected word by word. What exactly constitutes malice aforethought? What is the legal difference between first and second-degree murder? These aren't abstract philosophical questions anymore. They are practical tools for building a verdict. Jurors will ask for transcripts of testimony, wanting to see the exact words a witness used on the stand. Did he say, "I saw a man," or "I saw the man"? A single word can change everything. The room becomes a whirlwind of debate. Voices rise and fall. Someone pulls out a whiteboard and starts drawing timelines, connecting names with lines, trying to make sense of the chaos. But this process is never purely logical. It is deeply, fundamentally human. Every juror brings their entire life into that room. The retired accountant meticulously scrutinizes the financial records, her pen scratching on a notepad. The young mother who has seen addiction in her own family views the defendant's testimony through a lens of empathy, or perhaps skepticism. The construction worker who has been in a few bar fights himself has a different perspective on what constitutes self-defense. These are not biases to be ignored. They are the lived experiences that the system relies on. They are the common sense of the community. Arguments break out. One juror is convinced of guilt from the first day. Their arms crossed, their minds seemingly made up. Another is a quiet holdout, picking at a single thread of doubt that no one else can see. They talk about their own lives, their own children, their own fears. They're not just debating the facts of the case. They're debating human nature, motivation, and morality. The pressure is immense. They're sequestered, cut off from their families, their jobs, the news. Their entire world shrinks to the size of that one room, and the only way out is to make a decision. In a criminal trial, that decision usually has to be unanimous. All 12 must agree. And the standard they must meet is one of the most famous and misunderstood phrases in the entire legal system. Beyond a reasonable doubt. This doesn't mean beyond any doubt. It doesn't mean to a mathematical certainty. The judge's instructions often describe it as a doubt that would cause a prudent person to hesitate before acting in a matter of importance in their own life. It's a gut check, but a gut check backed by evidence. This is where the battle is truly fought in the jury room. What is reasonable? One juror's reasonable doubt is another's wild conspiracy theory. One juror's solid evidence is another's circumstantial coincidence. Hours turn into days. They take vote after vote. 10-2, 11-1. The holdout becomes the center of attention. They are cajoled, pressured, reasoned with. They must explain their doubt, defend it against the certainty of the 11 others. It's an agonizing position to be in, to stand alone against the group, knowing you are the only thing preventing a verdict. What happens if they just can't agree? This is the dreaded hung jury. After days of deliberation, if the jurors are hopelessly deadlocked, the foreperson has to write a note to the judge. The note is carried by the bailiff into the silent, waiting courtroom. The judge reads it and announces that the jury is at an impasse. Often, the judge will bring the jurors back into the courtroom and give them what's known as an Allen charge or a dynamite charge. It's a carefully worded instruction urging them to give it one more try. The judge will ask the minority to reconsider the majority's opinion, and the majority to reconsider the minority's, reminding them of the time and expense of a trial and the need to reach a decision if they can do so without violating their conscience. It's a last-ditch effort to break the logjam. If it fails, the judge has no choice but to declare a mistrial. The defendant is neither guilty nor innocent. The entire process, the investigation, the arrests, the weeks of trial, ends in a draw. The prosecution must then decide whether to start all over again with a new trial and a new jury. But in most cases, a decision is reached. The final holdout is persuaded, or perhaps they persuade someone else. A consensus forms. A final solemn vote is taken. Hands are raised one by one. It is unanimous. The foreperson takes the verdict form. It's a simple piece of paper, often with checkboxes. Guilty. Not guilty. For each charge, they mark the collective decision of the 12. The foreperson signs it. The debate is over. A profound silence falls over the room. The decision is made. The foreperson sends a note to the bailiff. The message is simple. We have a verdict. The news ripples through the courthouse. Lawyers who were slumped in their chairs suddenly sit bolt upright. The defendant is brought back into the courtroom, their face a mask of anxiety. Family members rush back to their seats, hands clutching each other, whispering prayers. The air becomes thick, heavy, electric. Everyone is waiting. The jury files back into the box. They look different now. They look exhausted, drained. They refuse to make eye contact with the defendant or the lawyers, a common instruction to avoid revealing anything. The courtroom is utterly silent. The only sound is the shuffling of feet, the creak of the wooden benches. The judge asks the foreperson, "Have you reached a verdict?" The foreperson stands and says, "Yes, we have, Your Honor." The bailiff takes the signed form from the foreperson's trembling hand and gives it to the court clerk. The clerk's hands rustle the paper, a sound that seems as loud as a gunshot in the silent room. The clerk looks at the judge, gets a nod and turns to face the defendant. Time seems to slow down. Every person in the room holds their breath. This is the moment. Everything has led to this single irreversible point in time. The clerk begins to read. In the matter of the state versus on the charge of, we the jury find the defendant. There is a pause that lasts an eternity, and then the word, guilty, or not guilty. An explosion of sound shatters the silence. A sob from the victim's family, a gasp from the defendant, the sharp, cracking sound of the judge's gavel striking the bench, demanding order. The trial is over. The machinery of justice has produced its result. For some, it is the beginning of a long prison sentence. For others, it is the first breath of freedom. But for everyone in that room, it is an ending, delivered by 12 ordinary citizens who were asked to perform an extraordinary task.